Most people panic when they see a trustee's essay like this one, but today I'm going to show you how the California Bar actually wants you to organize it. And yes, future lawyers, it's December, it's holiday season, so consider this my Christmas gift to you. We are breaking down every essay question from the July 2025 California Bar exam. So grab your coffee, settle in, and let's dive into these essays the way real lawyers do. And if you're new here, welcome. I'm Vinicius Costa, a foreign-trained lawyer who passed the California Bar on my first attempt. And I'm here to help you master the California Bar just like I did. And a quick announcement before we jump in. Since it's the holiday season, Aureus Bar Prep is launching our end-of-year promotion this December. Christmas is on 25, right? So you get 25% off all study packages until the end of December 2025. If you're taking the February or July 2026 exam, this is your moment. The link is in the description below. And now, let's get into the essay. So, today we are jumping into question 1, a full trustees analysis. And trust me, you're gonna want to see how this one unfolds. Before we start, just a quick disclaimer. This video represents only my personal interpretation of the released exam question, and is intended only for educational purposes. There is no tie to the California Bar itself. And a tip for you. On your exam day, you have a whiteboard with you that I highly recommend you to take notes as you are reading the question. So here's the situation. Let me walk you through the key facts because trust essays, it's all about organizing the story. Grandma dies in 2020. Her will creates two separate trusts, the farm trust and the ancestry trust. And she splits the residual estate 50-50. She also writes a backup clause. If any of the trusts fail, the assets go to her granddaughter's children named Betty. So that's the situation so far. Fast forward a few years. The farm trust is supposed to remain an organic farm in perpetuity, but it loses organic qualification. The trustee, bank, wants to allow pesticides. So initially, we have a potential conflict with the settlor's intent. Then we move to the ancestry trust. It's an income trust. Income goes equally to 3 grandchildren, Tom, Betty, and Carol. And Tom is also the trustee. Tom gets into medical debt. He improperly writes himself a check from the trust. He plans to repay it, but dies. There is no successor trustee name. And finally, Betty petitions the court to 1. Dissolve the farm trust, 2. Dissolve the ancestry trust, and 3. Order Tom's estate to repay the money. So now, we need to discuss whether the court should grant Betty's petition to dissolve the farm trust, the ancestry trust, and if Tom's estate should repay ancestry trust. First of all, remember this question involves 2 trusts, the farm trust and the ancestry trust. Each one has unique terms and factual challenges. The farm trust requires that the farm be operated forever as a farm, preferred as an organic certified farm. The ancestry trust, on the other hand, distributes income yearly to beneficiaries with Tom as trustee. The key controversies include a breach by trustee Tom, using trust funds for personal debt, loss of organic certification in the farm trust, and whether beneficiaries can force dissolution and repayment. My recommendation for you is that you start listing all relevant topics for this answer. It is extremely important to do that so you can score more points in your final answer. You could start your response clarifying that, since the question states the will is a valid one, no assessment of the will requirements will be made. If you have time, you could include a sentence or two defining what is a will and the key requirements. But only if you have time. In my opinion, a good response for this question would include standing of Betty to petition, rule against perpetuities, general principles of trust, trust terms, trustee duties, breach, deviation from terms and failure for both trusts, Cypress doctrine, standing and objections of bank and others, and repayment by Tom's estate, which would include a fact of trustee breach, personal liability, actable remedies, and state responsibilities. We will go through each one in short segments, so if you're taking notes, mark a line for each issue. Let's start with standing. Beneficiaries generally have the right to petition a court regarding trust administration. The farm trust was created for the benefit of the city. The will states that if the farm trust fails, its assets should be given to the children of the will's grandchildren, Betty. This provision gives Betty a contingent interest in the assets of the farm trust. Betty's interest under the farm trust is contingent because it depends on the occurrence of a future uncertain event, such as her survivor or her daughter meeting certain conditions. And when we talk about future conditions, what should we always remember? Rule against perpetuities, of course, which I will simply refer as RAP or RAP. Yes, Betty's interest should be analyzed under RAP. And this happens because contingent interests are subject to potential invalidation if they might vest beyond the permissible period. RAP provides that no property interest is valid unless it must vest, if at all, no later than 21 years after the death of a living being at the creation of the interest. Here, Betty's contingent interest and any interest created for her daughter must vest, if ever, within the permissible perpetuities period. If the trust allows the property to remain unvested beyond lives in being plus 21 years, the contingent gifts would be void ab initio. But because Betty was alive at the trust's creation, any gift conditional on her life or death would likely satisfy RAP. Any condition that turns on Betty's own life or death, such as if Betty survives some person or if Betty has a child, must necessarily be resolved within her lifetime. Therefore, such an interest will either vest or fail no later than Betty's death. The key question here when facing a RAP problem is, could this interest possibly vest more than 21 years after the death of someone alive when the interest was created? If no, then the interest does not satisfy RAP. Therefore, since Betty's interest is valid, Betty has standing to petition the court. Also, Betty is a beneficiary of Ancestry Trust. Thus, Betty also has standing for Ancestry Trust. However, you should remember that trust law, and more specifically, under California Probate Code Section 15403, requires all beneficiaries to consent before a trust can be modified or terminated unless the court reduces this consent requirement. So, Betty can petition, but dissolution or modification needs anonymous beneficiary consent or judicial approval to proceed. Standing allows petitioning, but consent requirements limit unilateral action. So, it would be more unlikely that the court would dissolve the trust. But let's keep digging into the other topics. Next topic would be trust general principles. A trust is a legal arrangement whereby a settler transfers property to a trustee to manage for the benefit of designated beneficiaries. You should memorize this concept, a legal arrangement by a settler where the settler transfers the property to a trustee for the benefit of others. The settler of a trust is the person who creates the trust and articulates its terms expressing their intent regarding how the trust property should be held, managed, and distributed. In this case, Grandma is the settler who, upon her death, established the farm trust by her will. The farm trust holds her residual estate, specifically the large farm, and directs specific terms for its operation. The will expressed that the settler preferred the farm to be used in perpetuity as an active organic certified farm on which no chemical pesticides were to be used. This language sets forth the settler's intent and the trust's purpose. The trustee, bank, has fiduciary duties to administer the trust in accordance with both the settler's express terms and applicable law, acting loyally and prudently to preserve the trust property and honor trust purpose for the beneficiaries. When organic certification was lost and pesticides used, this likely breached the trustee's fiduciary duties. But also remember that the question points out that the farm lost its organic certification for reasons beyond the bank's control. This may serve as a factor to mitigate trustee's liability. However, the fact that the trustee would allow city to use pesticides on the farm could be considered to show a breach. The key question here is whether this breach causes trust failure, which would allow dissolution. California law distinguishes between mere deviation from terms and trust failure. If the trust purpose continues, meaning a farm operation, the court might allow modification via Cypress doctrine instead of dissolution. In such case, bank, the trustee, would argue the trust continues. Betty, on the other hand, would argue the deviation is fundamental. The court then weighs whether the breach frustrates the purpose, or can be cured. Remember, the farm trust can be classified as a charitable trust because it was established for a public benefit purpose, the use of the farm for the general benefit of the city, and it operates as an organic certified farm. Charitable trusts differ from private trusts in that they serve public or charitable goals rather than solely benefiting individuals. Generally, trusts are classified into several types based on their purpose and terms. Private trusts are created to benefit specific individuals or families. Beneficiaries have an enforceable right to the trust property or income. Charitable trusts are established for purposes beneficial to the community or society, such as education, health, or religion. These trusts enjoy special legal treatment, such as an indefinite duration and broader standing to enforce. On your response, you should also mention Cypress doctrine. Cypress is a legal principle applied primarily to charitable trusts when the original trust purpose becomes impossible, impracticable, or unlawful to fulfill. Instead of allowing the trust to fail, the court modifies the trust by redirecting the trust purpose to a purpose reasonably close to the setter's original intent. Cypress applies when the original charitable or specific purpose is no longer achievable and the setter had a general charitable intent. If the setter's intent is highly restrictive, courts are less likely to apply Cypress. In our question here, the trust's purpose is to benefit the city with an active organic certified farm. The loss of organic certification and the need to use pesticides makes the original purpose impracticable. But the setter had a general charitable intent to benefit the city through a farm. Remember that. Thus, the court could apply Cypress to modify the trust to allow pesticide use, which would be as near as possible to the original purpose of the trust. Next topic would be standing and objections of bank and others. Here, both bank, which is a trustee, Carol as a beneficiary, and Tom's estate have objected. Since the farm trust's charitable purpose remains viable and the ancestry trust can continue to operate, the court is unlikely to terminate either trust. Instead, the court would consider appointing a new trustee for the ancestry trust and possibly modifying the farm trust to align with Grandma's original intent. Thus, while Betty can properly bring the petition, she is unlikely to succeed in dissolving the trusts over the objections of the other parties. With respect to the breach of the trustee's duties, the court must decide if the breach and the trustee absence frustrate trust purpose or if a new trustee can carry on administration. This is a factual and legal balancing test. Finally, we need to analyze whether Tom's estate must repay the funds he withdrew from the ancestry trust to pay his personal debts. As trustee, Tom owed fiduciary duties of loyalty, care, and segregation of trust assets. By using trust funds for personal expenses, he breached those duties and committed self-dealing. Remember, an easy way to memorize trustee's duties is, and I did slide. When a trustee breaches fiduciary duty, actable remedies apply. The trustee, or if deceased, the trustee's estate, is personally liable to restore the trust property or its value, plus any lost profits. Thus, Tom's estate would be required to reimburse the trust for the withdrawn funds, with possible interest to make the beneficiaries whole. And remember, because Betty is a beneficiary of the ancestry trust, she is entitled to seek this remedy on behalf of the trust. So, to summarize, Betty has standing but needs beneficiary consent for modification or dissolution. Farm trust breach is relevant but may allow modification rather than dissolution. Tom's estate likely liable to repay misused funds, and remedies balance trust, trust terms, law, and beneficiary interests. That wraps up the analysis of this July 2025 California Bar Exam Trusts question. Understanding trust, standing, trustee duties, breach, and legal remedies is crucial for the exam and real-world practice. If you found this helpful, make sure to check out our Aureus Bar Prep materials, where we turn every major bar topic, like this one, into visual summaries, flowcharts, and practice sets made specially for busy professionals and foreign-trained lawyers. You can download a free sample at aureusbarprep.com or at the link below to see how we make complex bar topics simple and structured. And don't forget our holiday season promotional discount. It is live until the end of 2025, 25% off all Aureus Bar Prep courses. Thanks for watching, stay focused, and I'll see you in the next video.